When you've scheduled your appointment to meet with your divorce attorney, there are some documents that would be helpful for your divorce attorney to have. If you have not yet filed divorce and you're looking to file for divorce, you're going to want to bring your marriage certificate. The court is going to want to first establish that there's a marriage to dissolve. So if you have it, please bring a copy. If you cannot find it, we can always order a copy for you, or the attorney you hire can order for you. In addition to that, the objective of a divorce without custody or even with custody, you're looking at your assets and your debts as well as your income. So any documentation that you have that could establish what your asset values are, what your debt values are, or what your incomes are is very helpful. That information can be gathered throughout the process. It's not critical, and you should not cancel your appointment if you do not have that documentation. But if you want your attorney to be able to give you a good idea of what you might expect as far as an outcome at the end, the more information you have regarding your assets and your debt and what your income levels are will be helpful. Eventually, you will need to get all of that documentation during the process. As far as what to expect at the initial meeting, the attorney is going to go through your objective and goals for divorce, because every case is different and everybody's goals are different. In some cases, people want to settle out of court, and your attorney might give you suggestions on how to best accomplish that, knowing and asking questions to you about what each of you desire in the end. Knowing your spouse is also an important part of trying to reach a settlement. If you know that your spouse wants to keep the home, and that's something extremely important to that person, you can craft an agreement that enables the person to keep the home. And you have to think of creative ways to do that, and what assets you would have to have that person give up in order for them to be able to keep the home. The first step that gets done after the divorce would be the initial filing of the complaint. So some of the information gathered in that appointment is going to be related to the history of your marriage, basic information like your addresses, where you've lived for the last 5 years, if it includes a custody component, and also going through an inventory of what your assets are and your debts. Even assets that you had prior to getting married need to be disclosed, as well as things you might have accumulated if you've already separated. While the spouse might not be entitled to those assets, it may be a factor in the distribution. In addition, increases in value of premarital assets are included. So a work history of where you've accumulated retirement plans is important, because they may have increased in value during your marriage, and you need to know that. Whether there's a prenuptial agreement. If you have one, it is critical that you bring a copy of your prenuptial agreement to your divorce meeting with your attorney, because that is going to, drive the outcome in your divorce. So if you have a document like that and you don't have access to it, you definitely want to try to get that before meeting with your attorney, because it will be a critical piece in the distribution of your debts and your assets. If child custody is part of your divorce, you're going to want to bring the information of your children, the history, information as to who has taken the children to the doctor, the dentist, the addresses of where they've lived for the last 5 years, because that has to be disclosed to the court, as well as who they've lived with. So you're going to want to bring that. A very easy to get and important piece of information you'll want to bring to your attorney is your income information. So if you're working for someone, please bring your most recent pay stub. You'll also want to bring a copy of the filed tax return, so that the attorney can look and see what your spouse was making, and if there was any additional income, such as investments or other income reported on the tax return. 2 other documents that are very easy to get, but sometimes are overlooked, would be your credit report. Every year, you're entitled to a free annual credit report from 3 different credit bureaus. At our office, we recommend that you obtain 1 credit report every 4 months, so that every 4 months you will have a credit report during your divorce, and instead of getting all 3 at one time. So if you want to get it from TransUnion, go to TransUnion, but bring a copy, because sometimes you don't know that your spouse opens up a credit card and that it's tied to your credit. But it's important to know in a divorce because you are trying to untangle anything that's joint. And if you don't know there's a joint card out there, it might not get addressed in your divorce. So you definitely want to do that. The other reason credit's important is it's going to help your attorney determine whether you have the ability to refinance a home if you want to keep it, or even if you're going to be able to get an apartment based on your credit. So it's important to bring that credit report, and if you can, a credit score. The other piece of information that's very easy to obtain that's no longer mailed out to people is your Social Security statement. Social Security is not a marital asset. It does not get divided in a divorce. However, it will give a prediction of what your income is going to look like in the future when you retire, or God forbid, if you became disabled. While you can take against your spouses if you've been married a certain period of time, it's important to also establish your work history and your earning capacity, especially if you haven't been in the workforce. It can show that you haven't been paying in the last 5 years or 10 years, and that you were a stay-at-home parent. So it's a critical piece of information that you should bring to your attorney, and you can obtain that right online at the Social Security website. Create an account and download it and bring it with you. You could also do that when you come in, should you forget any of your documentation. But the initial stage, like I said, will be the preparation of a divorce complaint if you are the party that wants to file. And it's a generic complaint in the sense that you're asking the court for equitable distribution. In your divorce complaint, you are not going to specify that you want to keep the house. You're not going to specify that you want 50% or 60% of the retirement account. You're not going to specify any percentages. You're just going to include a count that tells the court that there are assets involved and that you do want the court to equitably divide them. You may also include a count for custody if custody is relevant, as well as if you are the dependent spouse, you'll want to include a claim for alimony. If you were served with a divorce complaint, when you come to the office, the other document you're going to want to bring is your divorce complaint and any hearing notices that have been generated by the court as a result of that. Any notices that you have received that you need to appear in court, or any documents that suggest there's a deadline, such as discovery, need to be brought with you to your attorney if you're hiring that attorney, so that they don't miss those deadlines and they can calendar that on their calendar. As far as what to expect if you've been served, you may or may not need to file an answer to the divorce complaint. Every divorce complaint is going to tell you you have 30 days to answer the divorce complaint. If you do not answer the divorce complaint and you do not have claims that need to be raised, nothing is going to happen to you. You do not have to file an answer to the divorce complaint. If a claim for equitable distribution or alimony has been raised by your spouse, you will not be getting divorced until an agreement is signed or it is heard by a judge. So you do not have to worry that a divorce is going to be entered without your consent. If you are the dependent spouse and you do need to file for alimony, you definitely want to raise a claim. So you're going to have to file an answer. If there are assets all in your spouse's name and they did not file for equitable distribution, just because they're in your spouse's name, you are still entitled to a share of those assets, whether they are retirement assets or even premarital assets that increase in value. So in those situations, you're also going to have to file an answer and raise a claim for equitable distribution. So you should definitely bring a copy of the divorce complaint so your attorney can review and see what claims have been raised. If you've received letters from your spouse's attorney, you're going to want to bring those letters with you as well. And then your attorney can go over any responses. If an agreement's been drafted that your spouse gave you to review, that they want you to sign off on it, do not sign off on that until you have had the chance to have your attorney review it. When you come into the office, everything will be gone over and a plan will be established, but in consideration of your goals. There are some people that want to settle quickly out of court. There are people that want to make sure they get every last penny they're entitled to. Your attorney is going to listen to your goals and develop a plan based on what they have heard you say you want. So please be candid with your attorney about anything, and important not to hide any important information, whether that's a new girlfriend or a new boyfriend or that you had an affair. Those things are all things you need to be able to confide in with your attorney. And if you don't feel that you can confide in your attorney, then you probably don't have the right attorney to be working with, and you need to consider that as well.